Welcome back. In this lecture, I want to finish up the Supreme Court, which will be the first of the three topics for this particular section. Judicial review is an intriguing concept because, of course, we take it for granted. Judicial review is simply the authority of the Supreme Court to nullify acts of government by declaring them unconstitutional. The biggest surprise to many students, and I will tell you that when I was an introductory student, it was kind of a surprise to me, is that this power, which is the ultimate power of the Supreme Court, it's not enumerated. You cannot open up your Constitution, look in Article 3, which deals with the Supreme Court, and it doesn't say anything about the Supreme Court having the authority to declare laws constitutional or unconstitutional. So the obvious first question is, well, okay, if the Constitution does not grant this power to the Supreme Court, how did the Supreme Court get this power? And kind of the short answer to this is the Supreme Court asserted this power for itself in the most important Supreme Court case ever decided in American history. If you were in class and I was putting stars on the board, I would put 12 stars on the board because this is literally the mother of all other cases. So Marbury versus Madison, as I may have mentioned earlier, one of the things that is intriguing about Supreme Court cases is that often the most important Supreme Court cases, the facts are often fairly trivial. So, for example, the facts in Gideon versus Wainwright was, did Clarence Earl Gideon break into a pool hall and steal quarters out of the various machines? Facts not very compelling. But the legal principle underlying this case, did the state of Florida have a Sixth Amendment obligation to provide him with an attorney at taxpayer expense? Incredibly important. And so essentially in Marbury versus Madison, the facts of the case aren't particularly compelling, except maybe to Mr. Marbury, right? The basic facts in this case are, is Mr. Marbury entitled to a job, in this case, to become Justice of the Peace for the District of Columbia, which clearly is not one of the important jobs in the federal judiciary. So in your notes that I've attached, I'll follow along with you, right? The facts aren't very significant. Adams made numerous judicial appointments to political allies, and most of the judicial appointments were successfully delivered. The justices took their oaths of office, and they had lifetime tenure. There was a small pool of justices whose commissions did not get delivered. And when the new president, Thomas Jefferson, took office, his Secretary of State, James Madison, notified him that, hey, Adams's guys and John Marshall, they screwed up. They didn't deliver these commissions. What should I do? And Jefferson said, well, don't deliver those commissions. We'll nominate our people to those jobs, and they'll have those jobs for the rest of their lives. So the controversy in this case, obviously, is, Marbury sues because he believes that he's entitled to this job. President Adams, had nominated him. He'd been confirmed by the Senate. The paperwork had been drawn up. It just needed to be delivered to him. He needed to present the paperwork, take the oath of office, and get his job. So Marbury does something in this case. There was a provision, and you may remember I talked earlier about the Judiciary Act of 1789. The most significant thing about the Judiciary Act of 1789 was that this is where the federal court system originated. Now, there was a very minor provision, and you don't need to know this number. It was Section 13. Section 13 of the Judiciary Act essentially allowed people to sue directly to the court In other words, the Supreme Court, instead of being an appellate court, would be a court of original jurisdiction. It would be a court order. And in Section 13, they had these things called writs of mandamus. And so Marbury sued, went directly to the Supreme Court and said, I want you, the Supreme Court, to issue a court order forcing Mr. Madison to give me my paperwork so that I can get my job. And of course, in this case, Marshall's in a tough spot. He's in a very tough spot for one reason, because he was the one who was responsible for delivering this commission, and there is a lot of historic debate about how and why the commission wasn't delivered. For our purposes, it doesn't matter, but it wasn't. And so Marshall had a second problem. And the second problem was that the President Jefferson, had gone public and said, I don't care what John Marshall and the Supreme Court decides. I've already nominated someone else to this court. They have that job. Even if I'm ordered to give up this commission, we're not going to do that. And of course, remember, the greatest weakness of all courts is they lack the power to enforce their decisions. So John Marshall understands that he cannot take Jefferson on successfully. He cannot win. And so what he does instead is that he does something for the first time in American history. He declares Section 13 unconstitutional. And I'm going to simplify this, and if you want a lot more detail, your textbook, Greenberg and Page, they do an excellent job of giving the details in this case. But essentially, in this particular case, what Marshall rules is that Section 13 of the Judiciary Act was actually an attempt to amend the Constitution, and that federal law, in this case a provision of the Judiciary Act, does not have the authority to amend the Constitution, because the Constitution is superior to ordinary acts of the Congress. In this case, Marshall says, of course, the Congress can propose a constitutional amendment and send it out to the states, and if they had done that, they certainly could add this provision, but they cannot. They cannot change the Constitution with an ordinary or basic federal law. And so what John Marshall was saying in this case is that the original jurisdiction of the Supreme Court is enumerated in the Constitution, that Section 13 was essentially a constitutional amendment or a constitutional change, and that they can't do that. If you look at your notes, it is the end of that section on judicial review that lays out the significance of this case. So what is the significance of Marbury versus Madison? Well, first of all, John Marshall rules that the Constitution is superior to ordinary acts of the Congress. And so this notion that we are a country with constitutional supremacy is firmly established in this case. I've heard some other people try to make the claim that this was a power grab by John Marshall. No, it wasn't a power grab at all. This guy had made a mistake, a serious mistake. He was trying to cover his butt up. This was the only occasion in 34 years on the Supreme Court that John Marshall struck down a law. It was the first and the only time that Marshall declared a federal law unconstitutional. It takes 54 years until Dred Scott, and I talked a little bit about Dred Scott earlier. I will talk about the Dred Scott case again when we get to civil rights. So this was the only case in over half a century that the Supreme Court nullified a federal law by striking it down and declaring it unconstitutional. So what should you know about this case? You should know that John Marshall established the doctrine of judicial review. You should know that he asserted constitutional supremacy, that the Constitution is superior to ordinary acts of the Congress. And so every single time that the Supreme Court strikes down a federal law, it is getting its authority from this particular case. And that's why legal scholars, and it's why I, in this video, and normally if we were still meeting in person, why I would say that I believe Marbury versus Madison is literally the mother of all other cases, because it is this case that the Supreme Court draws its authority in declaring and nullifying acts of the Congress, or declaring the constitutionality of law. So this video is a little bit shorter. It's only about 11 minutes, but we have now concluded the Supreme Court. We are going to move next to what I consider my favorite part. You guys know how I love to rank things. So we're going to move into civil liberties. And the next lecture is going to be entitled Civil Liberties for Me But Not Thee. And I think you're going to really enjoy this section, because I really, really do. So hope that these videos are instructive. Hopefully you're able to get online and see these videos, and hopefully they're kind of illustrating your lecture notes that are already there. So have a wonderful, wonderful day, everyone. See you next time.